Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy to have you guys on this Tuesday. Normally, I would be doing my streams Monday, Wednesday, Friday, but I had to postpone the stream yesterday to today. No big deal, just kind of a thing. If you were a member of my Discord, you'd actually know the reasons for it. But so there you go, join my Discord. Anyway, tonight, something I've been wanting to do for a while. It is uh an audio journey of a sovereign citizen in Texas who got a speeding ticket at the end of August last year, and we're gonna go through his pre-trial, um, and eventual trial. The thing is that it's all audio. So to make up for that, I'll be playing a new character in Skyrim. Why Skyrim? I mean, why not Skyrim? That's the bigger question. Why not Skyrim? So that'll be playing while the audio will be of the two preliminary hearings and then the actual trial that was held on November 29th. So, it's one of these, going to be a very chill stream, very laid back. I'll try to pause very sparingly. So this is something that you guys can listen to while you're working, doing housework, doing chores. Need to watch my ugly face. So to set you up, the individual was again cited for speeding. This is actually a copy of the complaint that he received at the end of the day. So what we're dealing with is this guy in this initial preliminary hearing, which takes place on September 20th, I think. A big point of emphasis is going to be that there's no charging instrument. There's no case that's been initiated against him. However, my understanding, and based on what I read for the in most states, and including Texas, if you plead not guilty to a speeding offense or a ticket, then you would be required to be served with a complaint. This is a copy of that complaint that he received by virtue of him not pleading not guilty. But he says that this doesn't count. This isn't. Yeah, he says this doesn't count for one reason or another that you're going to hear. It's asinine. He says that he can't decipher this coded language, TRC 545.351, 545.352. He says they don't exist. They do exist. It's a Texas transportation code, section 545.351, which has the maximum speed limits, and 545.352, which establishes the prima facie violations, prima facie cases for speeding offenses. So they do exist. He just says nah. He's a very arrogant, I would say, individual. And we'll find out later on. But he definitely has a very high opinion of his knowledge on Texas procedure and the statutes. But at the end of the day, he is your garden variety right to travel. It's only applicable to commercial vehicles, yada yada yada, the same stuff that you and I have heard countless times over. So with that said, I'm gonna start with the September 20th pretrial hearing while I load up the Skyrim.
2022. We're gonna go in here to the JP court and see about a speeding ticket.
Why is this not working?
Morning. All right, we got some of that sticky on my hand. Over here, I'm going to show you something. We got, see right here, justice of the peace. That's it. In a lot of different kinds of courts, they call the judge something different. Usually it's just judge, but here in this kind of court,
Principal too.
precinct 2, they call it a justice of the peace, or JP court. And they put honorable, the word honorable in front of whatever judge's name. So, honorable David Evans, or whatever, they put honorable in front of it. It's like the minister. This is the lady judge.
Here.
Mm-hmm.
Wait, come on. This needs to be working. Right. Whoops, that's my bad. No wonder I messed up.
I'm going to show you something. You got
There we go.
yes, part of his civics class.
Oh god, I think he's okay. I did not realize this, but I think he brought his kid along to this hearing, which is, I mean, sure, it's good to, for your kid to come in to learn, civics, but not when you're a sovereign citizen.
You want me to be up here? All right.
So what's your name, young man?
The white noise is him censoring his name, and obviously his son's name. Just an FYI, it's not a glitch in the audio.
Wrong name. So you gotta be an attorney?
An attorney? No.
Oh, okay. So get that?
He wants to be an inventor.
No.
Better.
No. It's an engineer.
Not with that attitude.
All right. I am Judge Holland. It's 9:30. This is my clerk, Casey Ricks, and my constable, Kelly Smith.
Morning.
And we have the VA's attorney, Cliff Thomas.
Cliff Thomas?
Cliff Thomas? Yes,
All right.
sir. All right, and this is gonna be case number T22-0519-2. Traffic citation. Anybody that's gonna testify, need to raise your right hand.
Hold on.
Truth, whole truth, nothing but the truth.
I don't
You're
know
gonna
anything.
testify. You're gonna raise your right hand. Yep. Promise to tell the truth, nothing but the truth, so help you God.
Yes, ma'am.
All righty.
I wasn't planning to testify, but yes, I only tell the truth.
Well, I believe it. I believe it. All right, you got a citation here that came up to $230. Tell us why we come here today. Why we're here today. What's going on with you?
Why are we here today? Well, that's a good question. That's exactly what I was wanting to ask of you.
Yes, sir.
Because it looks to me like I don't see a reason in law for us to be here.
Yes, sir.
It looks to me like we have a challenge to the jurisdiction of the court that's before the court, and I didn't see any evidence produced yet for that. So that's probably the first thing. That's a threshold issue.
Yes, sir. Mr.
Jurisdiction.
Anything on this?
Judge,
Oh god.
we're here today on a pretrial hearing, but that's to determine whether the defendant wants to plead not guilty and ask for a trial, or talk to me and try to work something out. That's normally what our pretrial docket is for. I did not get any notice that we were going to have a jurisdictional issue heard today. Didn't get any motions filed and requests for settings for today. So
Right.
not prepared to hear any motions or issues,
Okay.
other than the fact that whether he wants to plead guilty or not guilty and ask for a trial.
All right. So I didn't have any way before now, knowing that Mr. Thomas here was intending to participate or to be an accuser or represent an accuser.
Accuser.
This is my first opportunity to provide any kind of pleadings or even know who is interested in stirring up a case. I don't see any case, and in the record, I don't see any primary pleadings from Mr. Thomas here. And I also filed a judicial notice in the record so that Your Honor would take notice of the fact that he did not file any primary pleadings, so this case can't start yet. I understand if somebody wants to bring up a complaint and bring it to Your Honor for the commencement of an examining trial, I understand that's a possibility. It hasn't happened. And at this point, I don't see any reason how he doesn't have any business participating in anything yet. He didn't file anything. Nobody's filed anything.
Well, on your ticket, it gives you a certain amount of days to come and make a plea, guilty, no contest, or not guilty.
Correct?
And that's what we were waiting on, so that's why we brought this
Okay.
to this courtroom.
The
so
plea
we
that I
can
have-
help you get down the street and we can get done with this too.
Sure. The plea that I have before the court right now is an exception to the charging instrument.
Okay.
And I've got some discovery that I have sent over to the DA's office after Ms. Ricks so kindly informed me that it was their office. I still didn't know who, but at least then I was able to go look up a fax number, and I got them some discovery requests so we can figure out what this is about.
So, first off, he tried to send a request for discovery to the prosecutor's office, which I think it does. I mean, it depends on the jurisdiction you're at. Discovery is a normal part of the process. But for traffic instances, I think the extent of the discovery you get usually is any body cam footage, radar stuff. But what he did isn't your normal request for discovery in a criminal matter. He sent out a request for answers and interrogatories directly to the prosecutor, which is no. That's not how that works. That involves, that's a civil thing, not a criminal thing. You don't get to ask the prosecutor like these questions, specifically like jurisdiction, specific traffic codes, things. That's not how that works.
And they have not responded at all. They've been completely unresponsive, ignoring me.
He
And
works for the DA though.
well, hopefully he'll be able to get some motion out of them if they have any interest in starting a case. Nobody has started a case yet. As far as I can tell, nobody's even filed any what's called the primary pleadings. They're not there. They don't exist yet. So if somebody
So would
wants,
you like for me to step out of here and so you can talk to Mr. Thomas about this?
no, I don't really have any interest in.
Okay. I just didn't want you to feel that you just were bound to me.
Oh, no, that's fine. If we're gonna have an examining trial today, that's great. Let's see it. Let's bring the witnesses. Let's bring the accuser, and I'm gonna cross-examine them, and that'll be great. But if there's no examining trial, we can't start a case yet. Nobody's filed anything.
Doug.
Well, you have a citation in this courtroom.
Yes, ma'am.
And that's the only thing we're trying to do is get to where we can get you to give us a plea, guilty, no contest or whatever, so we can go ahead and get this over with. It's $230.
Yes, ma'am. And I realize that's the normal procedure, and that's
Yes, sir.
let's just say that's the way things are done around here. I get that. Also, when I read the law, and I'm sure if Your Honor will notice that as well, that's not the pattern that's laid out, the due process that's laid out for us in law. A citation doesn't commence a case. It can't commence a case. It's impossible. There's no way in law for a citation to start something. I get that a citation was issued, and out there on the side of the road, it has a notice to appear section and a promise to appear section, and I did appear. I came here 3 times. Now, I would contend that signature was applied against my will and under duress, and I'm standing there, shaking next to some guy with a weapon, and I don't know what kind of training he's had, but I want to cooperate and all of
They
that.
all carry weapons.
Yes, exactly. So, and I'm glad they do. They got jobs that need that. However, I didn't intend to sign anything. I'm only signing it because he had me to sign it. Well, regardless, whether it's a legit signature or not, I came in here and I did appear within the time frame that was specified on that document. I got it over here if you probably have it in front of you as well. It said before the 30th, on or before the 30th, and I did that. I've been here actually 3 times. Ms. Ricks wouldn't let me see you. I understand there's some concern about maybe somebody's going to have an ex parte communication or something. And I get that. But I actually wasn't coming to see you about that I had a need for you in your magisterial capacity, and that didn't work out that way. Anyway, I've been here 3 times. I fulfilled any promise that anybody might have thought I had, but the citation can't start a case. And
Mr.
Yes, it can, and it can. But here we go. Now we're getting into the meat of it.
keeps saying that, but he's not providing any legal reason or any legal grounds to show that. If he has something, case law or statute that shows that, I would ask him to produce that to the court. For speeding ticket, he was issued a ticket, but he's also issued a complaint, and the complaint is the charging instrument. That starts the case. All I have to do is prove the complaint as to whether he was speeding or not. And that's not for today, but it will be for the trial if that's what he wants.
If you want a trial, we can set you up for a
And
trial.
that's why we're here today, is whether he wants to speak to me to try to agree to something, or if he wants a trial.
okay, and I'm sure that time might come. That time is not yet. Since a case has not been commenced, I've got a challenge to jurisdiction before this court. This court's going to need to prove up some jurisdiction, which probably, usually, Your Honor would lean toward the prosecutor and say, show me something. Where did this come from? Well, he doesn't have anything.
Well, yes, Your Honor, there's jurisdiction in the ticket. There's a place he was stopped, and if it's in Wood County has jurisdiction. So he needs to provide something to show we don't.
All right, it's not, the burden of proof is not on me, but let me just highlight for Your Honor that he seems to be confused. He's thinking only about territorial jurisdiction, and that's one of 3 important legs.
No, it is the lawyer who is wrong.
There's also subject matter jurisdiction, which he has no way to prove up, and also in personam jurisdiction, me specifically. Why me? Not just, does this court handle this kind of case, and does this court handle things in this particular area, but why me? I had to have been served with some primary pleadings which don't exist.
He was given the ticket.
So when this Mr. Thomas here is speaking to, he made an assertion, Your Honor. He said that a complaint is the charging instrument, and I would ask that he would prove that up. Burden of proof is on him, not on me.
Your Honor,
Uh-oh.
Mr. seems to be confusing civil law with JP criminal ticket. In civil law, some of the issues that he's bringing up about jurisdiction, in personam, subject matter, all of those have to do with civil cases. If he doesn't reside here and we're trying to bring him to Texas for a case, then we have to prove either subject matter jurisdiction over him, or that we have jurisdiction personally over him, that he's been here. There is a list to show that Texas has jurisdiction in order to bring a civil case against him in state courts of Texas. Mr. was speeding, operating a motor vehicle.
Speeding. Objection.
Those are the
You've got this guy
allegations.
over here trying to testify. That's hearsay. That we can't have that.
Mr. Are you an attorney?
He's not testifying. He should have said allegedly speeding, but he's not testifying. We're not here to try the merits of the case. So shut the hell up. You don't know what you're talking about.
I'm asking, are you an attorney?
I'm not going to respond to.
Because you are confusing and mixing different types of cases, you're throwing out phrases and words that do apply in court, but not in a JP court for a traffic.
All right, Your Honor, he's Mr. Thomas here is somehow imagining that the rules of civil don't apply here.
They don't, you know.
And
They don't.
if he wants to make that assertion, I'm going to ask him to prove that up too, because that's going to be a big thing for him to come up with.
Chapter 45.
JP courts are different from.
Yes, ma'am, I get that.
Chapter
And-
45 of the Code of Criminal Procedure, Your Honor, the rules of civil procedure don't apply in JP court. The rules of evidence do apply in a criminal case in JP court, not in civil cases. But the rules of civil procedure don't apply in JP court.
Your Honor, Mr. Thomas is confusing 2 things together when he's saying that there are special rules that apply in a JP court, which is true, And then he folds that right over into a civil doesn't apply, which is not true. And if civil did not apply, there would be so many things that couldn't happen. We couldn't schedule, couldn't calculate dates. How do you serve motions? None of that would be possible.
We're not
if civil
talking about
didn't
that
apply.
though.
So what we need to determine today is, do you want to take this to trial?
If somebody wants to have a case, I'm going to demand that there be some primary pleadings on the case, but that's actually not, it's not time for that either. There needs to be an examining trial first. Mr. Thomas is referring to the existence of a complaint. It's insufficient on its face, but let's just say that that complaint were brought to your honor, and now you have a magisterial duty to hold an examining trial.
Thank you, Deacon, for the $5 super
I
chat.
wasn't included on that. That hasn't happened.
Your Honor,
Code of Criminal
examining
Procedure
trials-
2701 says that the primary
God.
pleadings, this is a criminal case, Code of Criminal Procedure, primary pleadings are the indictment or the information. There's no mention of, oh, but only if it's a misdemeanor, doesn't get to, nothing. It's only, there's one very simple statement there. It's a short sentence, and I believe everybody can understand it. Primary pleadings on part of the state are indictment or an information. Those don't exist in the case, Your Honor, as indicated by the judicial
Sir,
notice.
those are for misdemeanors and felonies. Felonies, the charging instrument is the indictment, and informations are normally, they can be indicted for misdemeanors, but informations are normally what's brought, what brings misdemeanors. Complaint is for traffic tickets, J.P. Fulton.
Hello, Jester.
Your Honor, let me clarify something. Mr. Thomas is working in an office where I'm sure they've been doing this particular pattern for a long time. However, that was repealed in 1999. What he's indicating doesn't exist anymore. The legislature fixed that for us. We don't have a complaint being the charging instrument. It used to say that in Code of Criminal Procedure 45.01, and they repealed it. They took it out. It doesn't exist anymore. They've got 3 case laws that they tend to, juggle around and try to point at to say, oh, this is why we can have a complaint be a charging instrument. However, all 3 of those are based solely on the repealed statute. 1999, Your Honor, that's a long time ago.
He's wrong. He's absolutely wrong. The charging, the complaint that derives from the ticket can serve as the charging instrument in a misdemeanor case.
I understand sometimes things move a little slowly in government offices and so forth, but they've had time to catch up. They can't start things with a complaint only. That's not a charging instrument. There's nowhere that you will find that being a charging instrument as like a replacement for an indictment or an information. He can look if he wants to, but the burden of proof, again, is on him. If we're just going to sit here and do he said, she said, hey, he's confused, no, he's conflating this, well, the burden of proof is completely on him. He's trying to start a case, and he doesn't have anything. He didn't file one shred of paper, and obviously didn't read any of the filings that I provided. So, if you want to start a case, let's start with an examining trial.
Your Honor, the examining trial is not mandatory. That the defendant has to ask for an examining trial.
Oh, shit.
But the purpose of today, again, we didn't come here to be prepared to argue any jurisdiction issues, any issues that Mr. has with the case. If he wants to do that.
See, this is what makes this this modded version of Skyrim so difficult for me, is that there's no health regen whatsoever.
Proper notice of hearing, give the Wood County DA's office.
And the food, the health you get from food has been substantially nerfed.
So that we can be prepared. Today's purpose is, does he want to plead guilty or does he want to ask for a trial?
Nope, neither one, Your Honor. Those are unacceptable. He's way far ahead of himself. We can't just jump to the part. There's no waiver in. He would be able to say
It
that.
doesn't seem like we're gonna get anywhere with this today.
Let me just highlight one quick thing. He would be able to go there if I had signed a waiver. In Code of Criminal Procedure 27.14, subsection D, there's an opportunity for me to sign a waiver to allow him to go through with this. Let's skip all the due process and go straight to the end where we have a trial. I didn't sign any such waiver. He didn't offer me any. I didn't even know his name until now. So there's no waiver. I want all my due process rights. I want you to start at the beginning if you want to start something. Right now there's nothing to start because nobody's filed anything. If he didn't come prepared for a pretrial today, somebody needs to apprise him of Code of Criminal Procedure 28.01 that tells what the reasons of a pretrial are. And every one of those in there he needs to be prepared for. What can I say?
Judge, that's just ludicrous. I mean, there's no way that, you talk about due process and people having notice. You don't get to come in and blindside and lay behind the log and ambush people. The purpose of today's hearing is he wants to plead guilty or not guilty. And that's it. And if he won't plead either, Judge, the statute says the court is to enter a plea of not guilty for him. And then we'll set a trial. And if he has motions to bring, wants hearings, he can file a proper notice and bring those issues before the court.
You have anything else, sir?
Yes, ma'am. I have a plea on file. He keeps trying to get me to plead to one of these not guilty or set a trial, which is kind of the same thing. So is not no contest. He's skipping the part where it says the pleadings of the defendant shall be, and subsection number 1, the very first one on the list, is a plea to an exception to the charging instrument. I have a problem with the charging instrument. I'm not charged with any offense according to the state of the laws of this state. There is no offense charged against me. If we look at the complaint, let's just imagine that for a moment it could magically transform itself into becoming a charging instrument. It doesn't charge me with any offense. There are 0 evidentiary facts alleged. How can we have a case where he's going to prove everything that was alleged and he didn't allege anything?
Judge, I don't know what document Mr. is referring to, but the complaint and the ticket both charge him with speeding. And that is a moving violation in the state of Texas. It also gives him...
You get a copy of this ticket so you can see that
Oh, yes,
you're
ma'am.
speeding.
I did.
It also puts the statute there and tells him exactly...
That's a good question, Jassa. Well, Jassa, sometimes, well, you can't. Well, you can't. Well, I almost want to say, like, sometimes the court will impose costs, but I feel like if you do that, it might set a bad precedent. Because whether or not a case wastes somebody's time is ultimately subjective. Even though you, me, and everybody else here know that this guy's wasting his time, you don't want to open that door to punish somebody for the subjective belief that they're bringing in BS, because it could serve as a deterrence towards being able to, a deterrence against wanting to fight your own case. If you feel like the punishment is going to be more severe simply for the fact that you tried to argue your case. So.
Let's take a look at this complaint, which is defective on its face, insufficient, and which was never served to me. It says, let's skip to the middle here. It says, defendant did then and there commit the offense of, and right there, there are no evidentiary facts, Your Honor. There's nothing that says this man was engaged in such and such regulated activity. He was going this fast, and there was nothing here that's mentioned at all. It says,
all right, I'm not ready for this area yet.
10% or more above posted speed, parenthesis, pound, parenthesis, TXTRC 545.351, semicolon 545.352, parenthesis. That doesn't exist. In Texas, there's no crime that is that. And there are no facts that anybody is alleging here. And the person who submitted this is a non-party to the case. It was e-filed from DPS. DPS is not a party. So I don't...
DPS is part of the state of it's part of the state of Texas. How is it? DPS is the Texas Department of Public Safety. They're part of the state. Yeah.
See what we're doing here yet. Back to my first question.
Wrote the citation.
Yes, ma'am. And that would be great if he were here as a witness. I'd cross-examine him.
But he doesn't need to be here for this. He'll need to be here for the trial.
He needs to be here for an examining trial, too.
We're not examining anything today. We're just trying to get a plea.
Okay, well, you got my plea.
Do you want to go to court? What do you want us to do for you?
I want you to dismiss this, Your Honor. I've
I want you to
got
dismiss.
the motion to dismiss before you. A copy's been provided to the DA's office of everything I filed. Ms. Ricks made sure of that. Thank you, ma'am. And then when I did find out the contact information for that office, I went ahead and provided on my own as well, through fax.
He sent it today. He was already on his way here. So.
No, not today.
Oh, okay.
No, I did the more than 7 days in advance. Yes, ma'am. He had plenty of time to be prepared. And so, you know, it seems weird that he's talking about how surprised he is this morning. But he's had all of this since the beginning. I came in here right after the ticket, which the ticket was 8/27. And I came in here, that was a Saturday, so I came in on Monday. I've been here 3 times that week. And I filed all this stuff, and I'm getting no response from their office at all. So maybe he's surprised today because they pulled him in here. Poor guy, they're just trying to, you know, they want somebody to be in trouble, but I don't know, Your Honor. I'm asking you to dismiss. I've got.
So it's also a recurring thing that this guy really acts like a condescending POS. Like I said, he's definitely one of the more egotistical of SovCits that we've met.
A motion to dismiss. It's before you. If he wants to try to oppose it,
And
let's
the
listen.
state opposes that, Your Honor.
On what grounds?
Don't have to have a ground, we oppose it. He's got a traffic ticket and complaint, and everything he's arguing, he can argue at trial.
Your Honor.
He's not giving any reason that needs to be dismissed. If he wants to
Read the
argue
motion.
facts, if he wants to argue facts, that has to be during the trial. We have to have the opportunity to bring up the witness and the officer.
Read the motion, Your Honor, or I can, if you like.
Judge, today's purpose is not to be reading motions and bringing any
Today's
kind of
purpose is
evidence.
just to establish a time so we can get you into a trial.
You're going to drag me 2,000 miles and have
And
me
that trial date is going to
leave.
be October the 18th or November the 15th. Which one works for you? October the 18th or November 15th?
No, ma'am. I'm going to raise an exception to that for judicial error of skipping over the part about jurisdiction.
Judge, if he needs a hearing prior to trial, we can have a hearing
Yeah,
pre-trial before the trial.
All of that can be taken care of then.
All right, so, Your Honor, are you saying that you're not going to address jurisdiction? Just for my clarity of what's...
This is not for that, sir. Only thing we're trying to do is establish a time to get you in here for trial or to get this taken care of.
All
And
right.
I want to help you as best I can, but I don't think you want me to.
Oh, I would love for you to, ma'am. It's a simple matter of following the law instead of following the patterns and the
You see what I'm saying?
policies of the way that the DA's office tends to run things. I understand it's more efficient for them to not have an examining trial, but it's ruining Texas. And I don't want to see it ruin Texas. I want to see justice not be trampled in the
I don't know why the lights aren't working, guys. I apologize.
streets. I want to see, you know, this is stealing from families. People get killed. This is not cool. There's destruction. We know who's trying to steal, kill, and destroy. It's not this man here, but the system is trampling justice, and I would love for you to do the right thing here, Your Honor.
Well, I'm going to try to do the right thing, but normally people give me a plea and I take them into my office and I work out something with them that really works on their behalf. But
Okay.
we didn't get that from you, so I never
Right.
got a chance to talk to you. You didn't give me the opportunity.
I sure tried to see you, ma'am.
You have to have a plea before you can come and talk to me about your case.
All right, my plea is an exception, a motion to set aside the charging instrument. It's an exception to the charging instrument.
You have to have a plea of not guilty or
See, what he's trying to say is this plea to set aside due to an issue with the charging instrument, that's only available in very limited circumstances. In particular, it's only available in I believe in felony cases that involve information or an indictment. Based on my reading of criminal procedure, I could be wrong. Furthermore, he might be too late at this juncture. I'm not sure. I'm not sure, but I think the primary issue is that this traffic case doesn't give you that option necessarily, because this is the justice of the peace court and not a district court.
No content.
Okay, Your Honor, I would ask you to take judicial notice of Texas Code of Criminal Procedure 27.02.
Yeah, see, he's citing Texas Code 27.02. What the fuck is that? Man, I'm dead. Texas Code 27.02. 27 is the general rules of criminal procedure. The rules of criminal procedure for the justice courts is section 45, not 27.
Subsection 1. 2702, subsection 1. It says the pleadings of the defendant shall be, and yes, it does mention this, not guilty, guilty, not that's part of it, no contest. But the first one on the list is, whoa, you got a problem with your paperwork. That's my plea. That's subsection number 1.
So we'll set this for a jury trial then. And it's either gonna be October the 18th or November the 15th. Which one works better for you?
I have threshold issues before the court. I have dispositive motions before the court. They stand unopposed, even though he says the word opposed. He didn't oppose it in any way.
Judge, I'm not sure why he's saying that. It's pretty definite when I say I oppose it, it's not unopposed.
That's a frivolous opposition, Your Honor. I move for sanctions against the
Sanctions?
DA's office and against Mr. Thomas here. Sanctions because this is a frivolous argument. Saying the word opposition is
And this entire hearing has not been frivolous at all.
not going to be
October the
enough.
18th or November 15th, which one do you prefer?
And the judge is still demanding the dates, and so I appreciate that she's still not letting him derail the whole situation.
Your Honor, I can't agree to either one of those. I've made my plea,
Okay,
and there
we'll
are
set it
threshold
for a date,
issues.
We'll mail it to you.
Okay,
Okay, thank you.
all right. Oh, I didn't bring a pen. Mr. Thomas, could I get your bar number?
No, sir. I don't have to give you my bar number.
All right.
If you want to look it up, I mean, there's ways to look it up.
All right. Could you tell me who you report to? Who's your boss? Mm-hmm.
District Attorney of Wood County.
No, I mean a man or woman's name.
Oh, no, you can look that up too. I mean,
Okay.
I will cooperate with you if you're trying to do something. Talk about privilege.
Well, that's exactly what I find it to be. Hope you have a nice day.
Hey, it was nice meeting you. You do that, you do what you got.
So ultimately,
Thank
Yes, sir.
Appreciate you.
Yes, sir.
You'll take care.
Thanks.
Have a good day.
Thanks. You too.
so ultimately, in between this next hearing, which I believe is October, it's not the trial. Yeah, the trial's on November 29th. The next hearing is in October, I believe. And I think since then, the defendant has since filed bar grievances against the attorney who was speaking, Thomas. And I think he tried to recuse the judge as well. So we're now going into the next one.
All right, this is Thursday, October 6th, 2022. We're going to go in here to the JP court and see about a speeding ticket. This is their second attempt at a pre-trial, and it should be preceded by an examining trial this time. Maybe the first one ever. Let's see. Good morning.
Go ahead and sign in, mister.
Hey, I got... Ms. Ricks, I wanted to take a quick look at the record if there's anything that's been filed by the opposing party.
Nothing's been filed.
Okay. All right. Thank you. Should I just go on in? Should I just go on in?
Go ahead and stand in line.
Okay.
Yeah, I forgot it was in my pocket, my bad.
Hey, Kelly. Good, how are you?
How are you, sir?
Morning, Kelly. Doing well.
You just stay with what you got. You got an armful. All right.
Open door on the left. Let me find Cheryl.
Awesome. Hey, buddy. How are you? Good to see you again. I know you don't have anything on you. There you go.
I normally would, but I didn't bring it in here.
Now he's excited as a boy.
Mine's in my car.
Yep.
I don't go nowhere without it.
Yeah.
Go bus. So Randy's leaving.
You all are welcome to come sit here in the jury box since we won't be using that today. We've got signature.
Yes. In both, I think this hearing as well as the next hearing, he has a gaggle of sycophants supporters, because of course they arrive in packs.
Cool.
Run out. Go ahead.
Oh, my.
Over there.
Over here? Yeah.
Now, I'm almost out of yours.
Morning, Mr. Thomas. How you have with you here today?
Well, this is another one of DA's, assistant DA.
Hi there. Logan?
Yes.
Logan Sawyer.
Nice to meet you.
Good to meet you.
Thank you, Dr. Nimrod, for the £2.69 super chat.
I'm Judge Holland. Nice to see you all this morning.
Good morning.
We're here on a case of state of Texas versus. We're gonna give him some time to tell us what's going on with him, and then we'll let the DA's office, Cliff Thomas and Logan Sawyer, talk to him about this, if that's what he wants to do. Mr. Can you go ahead and tell us what's going on?
What's going on?
Let me swear everybody else in. Let me swear everybody in. Promise to tell the whole truth, nothing but the truth, so help you guys.
Absolutely.
Thank you, Mr.
Did you guys swear?
No, we're not witnesses.
All right. I'll hold you to it.
Shut the hell up. You missed that. He asked, did you guys not swear? And they're like, no. To the other attorneys, they're like, no, we're not witnesses.
Well, from what I understand, Mr. Thomas here would like to start a case against me. And he actually has pretended to this court that a case already started, but he didn't file anything. So in order for somebody to start a case, somebody's going to need to come to Your Honor first with a sworn affidavit with some facts on there, some evidentiary facts, so that Your Honor would be able to make a ruling, a determination on probable cause. Hey, do we need to start a case or not? And then at that point, then we can get moving with all these things that he's trying to do. That's what the examining trial, I think you mentioned last time when we had a pretrial, and everybody was really itching to have a plea, which is something that happens in arraignment. An arraignment is improper at that time per the Texas Code of Criminal Procedure 2603, which says that can only happen after there's been an indictment or an information that's served on the defendant and 2 days for me to chew on it. I'm paraphrasing a little bit, but it needs to arrive. It doesn't even exist yet. So they're jumping the gun. They're getting way ahead of themselves, trying to hurry up to get to the part where we bang the gavel and they can collect their $230, but we're not there yet. So first there needs to be an examining trial, and that's what was scheduled for today. Examining trial and then a pretrial. I'm sure the pretrial will become moot if the examining trial doesn't result in Your Honor coming up with a determination of probable cause to start a case. Sure.
Mr. Thomas, Mr. Song?
May I remain seated, Your Honor?
Yes, sir.
I just need to, if the court would ask Mr. Is this all his arguments for today, or what are all his arguments? I want him to have the opportunity, all the opportunity to argue before the court, whatever it is he wants to argue, before I respond.
Do you have anything else, sir?
I refuse to put my rights all in a box up front and say this is the only thing I'm going to argue. It depends on what Mr. Thomas, what kind of lawlessness he decides he would like to bring to this court, and I reserve my right to address that at the time whenever I see what it is. I do have a lot of motions and pleadings before the court. I'm sure Your Honor has noticed, but those are not really ripe yet until a case gets commenced. If he wants to pretend like there's a case, he is going to have to help this court prove to me that jurisdiction has been invoked. And the only way that I know he can do that is by showing that due process was followed. On September 20th, he had an opportunity at pretrial to bring that up, but he didn't. Instead, he lied to this court and said due process is only for civil issues.
Now, I don't think he ever actually said that. So he's lying to the court right now. Yeah, no, he never, the prosecuting attorney never said that.
Well, I'm sorry, but I can't go with that. And in fact, I think that is actually unfitness as an attorney. He can't even
Oh my God.
be here. Now, if somebody wants to follow due process, great, I'm here, let's do that. Got to start with an examining trial, though.
Judge, whatever the court wants to do, but this is a pretrial hearing for Mr. I just want to be sure he's had every opportunity to argue whatever pretrial issue he has. If the court wants to piecemeal it and say, we'll argue the examining trial first, we can do that. Or if he has other issues, Judge, I want to give him every opportunity. Now, I do take exception to his disingenuous statement about me lying to the court about due process. Due process is the very foundation of the criminal justice system.
Thank you.
And I recognize that. I would never say it's not applicable in criminal situations. I didn't say that. So it is the very foundation for our whole justice system.
I do have quite a few pretrial issues. However, like I said, those are not ripe until a case commences. A case can only commence. I'm very glad that he's at least acknowledging now, even though he didn't on the 20th, that due process applies here. I don't really want to get into charging him with the crime of aggravated perjury right now. It does apply. However, I'd really rather just deal with this one issue of he's trying to start a case. He hasn't done it yet. There's nobody here. I see that he came unprepared once again, did not bring anybody who could be called up as a witness. Now, in an examining trial, as he knows or should know, any attorney should know that an examining trial is for the purpose of me to be able to make a statement before the magistrate, for the witnesses to be able to make a statement before the magistrate. He brought no witnesses. I'm supposed to be able to cross-examine the witnesses per 1603 Code of Criminal Procedure. I need to be able to do that. 1608, 1610, I need to get these people in here. Well, I don't. Whoever it is that's trying to pretend like there's a case going to be commenced. So that would be Mr. Thomas here. He wants to say that there's going to be a case.
Pretty good, Nimron.
Some witnesses.
Baddies.
Let's get it to the point where
Obnoxious.
we'll be able to hear some probable cause, evidentiary facts, and make a determination. If taken as true, these are a crime and would need to go to court. He didn't do that. I see nobody here. So I don't know how he's going to do that. Like he said, he can't testify.
Judge, Mr. is under the faulty premise that that he gets an examining trial. That time has passed, and his premise is faulty, saying that there's no case filed. On the complaint being filed by the state of Texas through the Department of Public Safety, that started the case. I didn't start the case, the Wood County District Attorney's Office didn't start the case. The case started when the Department of Public Safety filed the citation and the complaint against me for speeding. So there is a case filed, and that complaint was filed. He's acknowledged receiving a copy of that complaint. That
Actually,
is the charging instrument, and with the charging instrument being handed down, he doesn't have a right to an examining trial. That established the probable cause.
So, Your
Now,
Honor,
if he wants to argue that, that's fine, Judge, and we'll argue whatever pretrial motions he has. We're here to assist him, and I want him to have every opportunity.
thank you. So, it seems that Mr. Thomas is confused again about examining trial. On the 20th, he stated to this court that defendants don't automatically get an examining trial. Now, I had been trying since the very beginning to get this thing done right through due process. The examining trial has to be the beginning. I've been saying that since day one. Now, Mr. Thomas said on September 20th, defendants don't automatically get an examining trial. The defendant has to ask for it. Well, I've been asking for it. So it's a little disingenuous of him to say here today that, well, that time has passed. No, that time has not passed, and there's no way that it can proceed to a case without any documents. He didn't file one shred of paper, Your Honor. Nothing. You know how much effort it was for me to try to even find out how to serve this guy? He doesn't really work for the DA. DA doesn't know who he is. They pass me around, transfer me everywhere.
Okay, so I waited until now to mention this, but Thomas, the opposing counsel, he's actually a private attorney, and I believe in Texas they do permit the prosecutor's office to outsource enforcing traffic citations to private counsel, here and there. So that is apparently what they're allowed to do in Texas. I think in other jurisdictions they do that as well. It's not unheard of, for private counsel to be hired to enforce, to act as the prosecutor for a case.
And somebody says they've heard of him, and I think he does some contract work sometimes, and oh my goodness, it was a lot of effort, Your Honor. And finally I got to where I could serve him something, and I know, Ms. Ricks, I appreciate that you were sending him copies of things. I didn't have that, whatever information you had, but I appreciate that you were giving him copies, but then I started giving him copies too. So for him to say that I haven't been asking for an examining trial is, again, that doesn't fit with the facts. And for him to also try to mislead this court right now and say that I don't have a right to an examining trial, I would ask this court to take judicial notice right now of 1517 Code of Criminal Procedure, which says that the magistrate must give the accused, which I guess he's hoping that would be me, even though he hasn't done anything to put me in that position. The magistrate must give the accused, must inform the accused of his right to an examining trial. Well, I do have that right, and that would be your place to make sure that I know that I have that right, so that it doesn't get to a position where somebody says, oh, that time has passed. He doesn't have what it takes to get to the examining trial, doesn't have what it takes to get through it, and I'm sure that's why he's trying to brush it under the rug right now.
Judge, and I object to Mr. somehow making this personal. I'm not bringing this case against him.
Just
Wood
facts.
County, Mr. I gave you your opportunity. If you no sidebar comments. Judge, if he's contacted
Wood County,
District
Texas.
Attorney's Office, the district attorney of this county has hired me to prosecute the justice courts of Wood County. I don't know who he's talking to up there. I've been up there, I go up there often, they know me, and have been doing the prosecutions for the district attorney for
Oh yeah, that's tiny.
several months now. So I don't know what he's talking about there. Now, what I also would ask the court to do is admonish Mr. He is delivering documents to my home, to my personal.
Yeah, if you just didn't just hear that, he's been going. He, as in the defendant, has been going to this attorney's private home physically to serve him documents, whether they be bar grievance or whatever. That's very weird, very unorthodox, and extremely inappropriate. You know, we're talking Blandino esque actions here.
Residence. And do you know how unnerving that is for my family? When a defendant walks up to our front door and leaves documents there. One of the times he left it, I wasn't home. The next time he brought something to my home, I met him outside and asked him to serve the Wood County District Attorney, not me personally. That's improper, that's unethical, that's inappropriate. And I'll stop there. He has also sent letters to my physical address. That's not appropriate in a criminal case. If he needs to serve me something, the Wood County District Attorney, P.O. Box 689, Quitman, Texas, 75783. Address it to the criminal district attorney. He can put my name, attention to me, it'll get to me. So I don't know who he's talking to up there, but it's just disingenuous what he's saying. This was not brought by me. This was brought by the Wood County Criminal District Attorney's Office pursuant to their duties in the government code. This was started by the state of Texas.
Your Honor, I object to this guy trying to testify. He's bringing up a whole lot of facts.
He's not testifying. Again, stop saying words you don't understand.
That have nothing to do with what's before the court.
And of course he's going to interject because this makes him look really, really effing bad.
And they're not even true.
I have laws.
I object. He can't testify.
If we need to have a hearing to whether he gets an examining trial judge, he's brought no evidence saying he has that right. I have a case here, Markle versus State of Texas, Court of Appeals, Texarkana, which is the Court of Appeals for this court for Wood County.
Objection, relevance.
Relevance is he has no right to an examining trial. And I'm about to read from this opinion why he doesn't. The right to an examining trial is waived unless the accused or his attorney requests one before the return of an indictment. An indictment is a charging instrument. If he asks for an examining trial before the return of the charging instrument, he gets
Wait.
Although I'll ask him
Stop interrupting.
not to interrupt again, Your Honor, if you would
I
admonish me.
object to him testifying. I object to him.
This isn't. I'm sorry. I apologize. This is not testimony. All right. I already made my point clear.
Bringing, yes.
Let him finish so we can see what he has to say. We listen to you.
Okay.
Thank you.
Although this is citing this case, Your Honor, I'm not testifying it's in this case. Although Markle was informed of his right to an examining trial and acknowledged he understood he had such right, he never requested one, and also waived that right. You can waive the right to an examining trial. If you don't request one, you don't get one, Judge, and that's what I said at our last hearing, and he's disparaged me, calling me a liar in front of the court and all these witnesses. That's the law, Judge. And there's a footnote also in this case that says the court noted in a footnote that no judicial determination of probable cause is necessary when the party is charged by indictment. The indictment is the charging instrument. Mr. doesn't get an examining trial because the complaint that was filed by the Department of Public Safety was the charging instrument. So the charging instrument's been filed. That's the probable cause. Examining trial is to establish probable cause. I agree with that. That has been established. It's time to go to the next phase.
Judge, if I may, on behalf of the District Attorney's Office.
So here is a direct representative from the District Attorney's Office, who's been sitting next to counsel.
There is a case that actually originated in this court. It's Ex parte Philip J. Emerson Jr. Citation is 06-20-00085-CR. In 2020, Mr. Emerson argued that the JP2 court, this court, erred in not giving him an examining trial. On page 6 of this opinion, what the Court of Appeals of Texarkana said is that, and I'll just quote it, Judge. It says, next, Emerson argues that he was entitled to an examining trial. We disagree. Article 15.17 of the Texas Code of Criminal Procedure directs magistrates to inform an accused person of his right to an examining trial. Citation, Texas Code of Criminal Procedure, annotated, Article 15.17. Article 15.17 is not expressly limited to persons accused of felonies. However,
Say that again?
Article 15.17 is not expressly limited to persons accused of felonies. However, the Texas Court of Criminal Appeals views Article 16.01, which governs examining trials, as constituting and defining an accused's right to an examining trial, and has held that Article 16.01 does not guarantee a misdemeanor defendant a right to an examining trial.
So there it is. Direct citation from a court in this very jurisdiction, that in misdemeanor offenses, you do not have a right to an examining trial. You can have one. The courts can allow it to happen, but you're not entitled to it.
The court cites Clark v. State, 417, Southwest 2nd, 402-403, Texas Court of Criminal Appeals, 1967. Because Emerson was arrested for and charged with a misdemeanor, the district court did not abuse its discretion in finding that he was not entitled to an examining trial. Mr. is charged with a Class C misdemeanor, not a felony. The law is very clear. He's not entitled to an examining trial. 1517 says that he's entitled to be informed of his right to one, subject to him having a right to one to begin with. Mr. cited other provisions of Chapter 16 of the Texas Code of Criminal Procedure, but he didn't cite the one that we need to know about. That's the very first one in Chapter 16. 16.01. Judge, if you read it, it's very clear. An accused of a felony shall have a right to an examining trial. There is nothing in there about misdemeanors. The courts have interpreted it for us. They've told us what the law is. The law says he doesn't get an examining trial.
Bam.
Absolutely. There's a big misunderstanding here about several things, and it was hard to keep track of them. They were coming out with so many things at once that are all wrong.
They're all
Start
wrong.
with Mr. Thomas's saying to the court here, let's not call it a lie, but he did say to the court that the case has commenced. And he says, he's putting words in my mouth saying that a case hasn't commenced because there's no case file, or saying that the case file somehow, just because poof it exists, a case file exists, that somehow due process has been followed, and that hasn't happened. Yes, I understand that Ms. Ricks is indexing documents that are handed to her, served to her for filing, and she has an index number at the top. However, there is no place in law that Mr. Thomas or Mr. Sawyer would be able to say that the filing from a DPS officer is somehow equivalent to a filing from their office, or probably just Mr. Sawyer's office, since the DA has told me on multiple occasions they can't figure out who I'm talking about. I've spoken with different people. They can't find him. They don't know who he is. They can't give me any email or fax for him. The only thing that anybody suggests is, well, maybe you should just email the main office. But when I do that, they don't know who he is. They cannot get something to him. That's what they've told me. So that aside, in order to start a case, there's no...
All right. Note that he hasn't really addressed yet the issue regarding an examining trial, which is something that he's been harping on for the vast majority of this hearing.
We're in law that says that you start a case by having a DPS officer e-file something. That is not how a case starts. Due process doesn't work that way. There's no provision for that. If he wants to make that assertion, then he's going to have to find something in law that says, here's how we start a case in JP2. It's different from everywhere else. And say that that happens with an e-file from a DPS officer. I understand, Your Honor. I get that this happens all the time. I'm trying to fix that. I'm trying to get us back to the law. I'm trying to get us back to where the law is respected instead.
Okay, so obviously he also has like a hero complex, or a was it a hero complex, messiah complex, one of them.
Of lawless policy.
I am trying to bring the rights back to the people.
Mr. Sawyer referenced 1601, and he misleads the court into it saying that I don't have a right to an examining trial just because this is a fine-only misdemeanor. It doesn't say
Savior
that
complex, there you go.
anywhere in there. He's making inferences and references just because it guarantees there's one particular person that they're making sure here, the legislators are making sure that this one particular person does get an examining trial, even if it happened already in some other county, even if he got dragged in, if it's a felony. And it says here, let me tell you the parts that he left out. There are qualifiers to what he just quoted a little piece of. The accused in any felony case shall have the right to an examining trial before indictment in the county having jurisdiction of the offense, whether he be in custody or on bail, at which time the magistrate at the hearing shall determine the amount of or sufficiency of bail, if a bailable case. Now this is speaking, Your Honor, not to who gets to have an examining trial or who doesn't, but it's speaking to, and the Court of Criminal Procedure, the Court of Criminal Appeals is exactly correct. 1601 doesn't say that everybody gets a right to an examining trial. That's not what it's saying here. But it is guaranteeing that one particular person in one particular situation can't be denied that. That's not me. This 1601 does not reference me or doesn't reference I have a right or I don't have a right. Neither one. It doesn't speak to that. That's why I didn't bring it up. It's not appropriate, doesn't fit. I understand that
because reasons.
1601 is where typically attorneys, district attorneys, county attorneys often go to that one and assume that it means that nobody else has a right to it. But if we were to go with such specious logic, Your Honor, then
specious
nobody
logic
has a right to an arraignment either.
No, that okay. I don't want to go into freaking debate, bro. But he's just dropping a lot of logical fallacies. Like, just at least the first one right there that he just said is like, you know, a red herring. I don't know where he gets this idea that because you're not entitled to an examining trial due to the fact that it's a misdemeanor means that you don't have a right to an arraignment. That's not what the Code of Criminal Procedure says.
And that happens all the time. Where does somebody have a right to an arraignment? That's not a right. That's just due process. I have a due process right to an examining trial because there's no other way to start a case. The magistrate needs to make a determination of probable cause based on evidentiary facts that are presented to the magistrate. And that hasn't happened, Your Honor. Now, here we have one other issue that that Mr. Thomas brought up is that I never requested an examining trial. Well, that's not true as
ultimately it doesn't matter whether or not you requested an examining trial, is because they demonstrated based upon a proper case law that you're not entitled to an examining trial regardless of whether or not you requested it.
The official court record reflects that's been a pretty common thread throughout. Mr. Thomas also is I'm sorry, he's misleading the court when he reads off this case law that talks about the indictment here, and then he switches out, his own words, he switches out charging instrument. Therefore, complaint must be charging instrument, must be indictment. And we can't go there, Your Honor. A complaint is a complaint. A complaint is not an indictment. If it says indictment,
Never said they were, straw man. But a complaint can serve as a charging instrument. Period. End of story. And that's all it needs to be. Not all it needs to be. A complaint can serve as a charging instrument. It does not need to be synonymous with an indictment.
those words are very specific from the legislature. They're not ambiguous. There's nothing unclear about what indictment means. So if Mr. Thomas would like to go find some case, which is just a judicial opinion, Your Honor, I'm sure you know.
It's just a judicial opinion, but some of these opinions can have precedential value.
This case that he's talking about sounds correct to me. It references an indictment, but he's trying to substitute that and say, oh, well, the indictment, which is something from a grand jury, can be somehow magically switched out, and we don't need that because we have an e-file something from the DPS.
Yes, they're allowed to do that.
The legislature doesn't authorize that.
Yes, it does.
Special way for a case to get commenced, and that's not it.
Yes, it does.
So, one other issue here, he says, is Mr. Thomas said that the complaint is the probable cause.
No,
Your Honor,
no, the complaint, he may have misstated, but what he was trying to say is that the complaint contains the evidence of probable cause.
I would just ask you, let that sink in. How
Shut
far
up.
from due process that is. How
God,
can
he's annoying.
a complaint be probable cause? There are no evidentiary facts on that complaint, Your Honor. Now, I understand that if it did have some evidentiary facts, and if all of those evidentiary facts were taken as true, which is what Your Honor will be doing in the examining trial, look at them, decide if taken as true, will they go to every essential element of any offense? Is there any cognizable offense against the laws of the state of Texas?
Yes.
That
He alleged that on a particular date that you were speeding.
all of those essential elements and would actually be a crime if taken as true. He didn't do that.
Yeah.
He didn't bring any evidentiary facts.
Except that the particular part of the code that he cited was prima facie evidence of a violation of speeding. And in that part of the code, it explicitly delineates what the speed the speed limits are in urban areas, non-urban areas, etc. And if the officer alleges in the complaint that you were that you were driving above the speed limit, in which it says there that you were driving 10% above the posted speed limit, there it is. That's prima facie evidence.
And he didn't bring a witness for us to cross-examine and try to get some evidentiary facts. He brought nothing. Nothing, Your Honor. We talked about bringing a knife to a gunfight. He brought a cotton ball. He brought nothing.
Oh, shut the hell up.
And so, I mean, the complaint that came from the DPS, the proper place for that to go is to you, Your Honor, and for there to be a determination of probable cause based on the evidentiary facts that are in it. But it's actually empty. It doesn't have any facts. It states some verbiage that's not even a crime, and it says it's trying to paraphrase the title of a crime, but that actually doesn't exist anywhere.
Well, you're willfully ignorant, and you're willfully stupid. Actually, I think you actually are stupid.
And it's like nothing stacked on nothing, Your Honor. Let's see, any other issues? So we're still talking about the examining trial and how inappropriate it is for this court or any court to bypass someone's right. Now let's talk about the right. Mr. Sawyer would love for this court to believe that I don't have a right just because 1601 doesn't talk about it. Mr. Thomas would love for this court to believe that there's no such thing as an examining trial in a misdemeanor. Well, as far as the latter, does it exist in a misdemeanor? I would ask that this court take judicial notice of Texas Code of Criminal Procedure 102.011, and it's subsection D. 102.011, subsection D. And in this provision, the legislature has made a reference to an examining trial in a misdemeanor. And so it obviously exists. It's speaking to how much does the sheriff get paid when he does this or that, and it's not pertinent in this case other than to just make it clear to Your Honor that it does exist in a misdemeanor. I realize that that's not what they normally do. They love to say it's only for a felony.
Yeah.
There's no law to back that up.
Except for the case law that they cited that has precedent.
Let's see here. Any other issues? There were a lot of things mentioned there. I think that's enough about the examining trial.
Judge, I just looked at the article in the Code of Criminal Procedure that Mr. referenced, and it says a defendant shall pay for the services of a sheriff or constable who serves process and attends an examining trial in a felony or misdemeanor case. The same reimbursement fees allowed for those services in the trial of a felony or misdemeanor, not to exceed $5.
Mm-hmm.
I don't know that he's paid anything, but maybe that is not really what he's talking about. I'm not saying he wouldn't be entitled to an examining trial, but the charging instrument is the complaint. It's already been handed down. That terminates his right to an examining trial. And Judge, if you want, I'll go. I've got numerous statutes. I've got 20 cases to reference today. I can go through all this, but I want Mr. to argue all his issues, and I can go through these. The issues that he's arguing are kind of all over the board. He's making statements of what I've said or what I haven't said. He said that case law is a judicial opinion. Case law is the law, Your Honor. Case law interprets the legislative laws, and that's their duty, is to interpret the legislature's laws. Case law is the law. That's what we follow. So I've already
Common law, bitches.
referenced one here where he's not entitled to an examining trial. I've got another one that's out of the Court of Criminal Appeals of Texas. He's not entitled to it. It's not an absolute right. Once the indictment is handed down, that's the charging instrument, and that's what an indictment is. Once the charging instrument is handed down, his rights to an examining trial are terminated because that establishes the probable cause of the crime.
There's no indictment.
That's what we're talking about in arguing. Whether he has,
Get that pause.
whether there was probable cause to charge him with speeding. And that's already happened by the complaint being filed by DPS.
Your Honor, I don't have the burden of proof here. Someone wants to make an accusation, the burden of proof is on the one who asserts. And Mr. Thomas has just now asserted, multiple times actually, that the complaint is the charging instrument.
Yeah.
And I realize that's a common way for it to be looked at. However, the statutes do not support such the statutes talk about what
But it does, though.
is and the sufficiency of a complaint.
Yeah.
But they don't give the complaint any magic superpowers to become an indictment or an information.
I hate how effing deceptive he's being with his language. He keeps on saying that, oh, the statute talks about what's sufficient to be in a complaint, but you know, it does. There's nothing in the statute that says a complaint magically turns into an information or indictment. It's not. The statute says that it serves as a charging instrument, which is sufficient enough in a justice court in Texas. You don't need to have an information or an indictment for this type of case, and he's being very weaselly with his freaking language, and it's infuriating every time he says it.
And that's the only thing that's constitutional, and that's exactly the wording that was used in this. Mr. Thomas brought some case law before this court to say that the indictment is what starts the case, and I completely agree. But there is no indictment. And he's trying to shift that over and now just make up legal determinations out of his own mouth with no grounds to support it, to say that the complaint equals the indictment. And I'm sorry, Your Honor, I can't go along with that. That's not the legislative intent, or they would have said that. In fact, they did used to say that. In 1999, or it was 95, yeah, 99, the legislature fixed that for us. It did say in the 45.01, it said the complaint is the charging instrument. And they've been running with it ever since, Your Honor, but that was repealed in 1999. The legislature fixed that. That was unconstitutional. You can't have anything except
the lighting needs work
according to the Constitution.
The hell is this weather?
I would ask this court to take judicial notice of the Texas Constitution, Article 5, Section 12B.
These God rays are too intense.
We can't have it be, well, the DPS e-filed a complaint, so that's going to take the place of everything. Nope, I'm sorry. That's not the legislative intent. And this court has no power to just go along with what the lawless policies are.
Lawless policies.
May I respond, Your Honor? Chapter 21 of the Code of Criminal Procedure, Article 21.011, filing of charging instrument or related document in electronic form, an indictment, comma, information, comma, complaint,
Bam!
comma, or other charging instrument
There!
or a related document in a criminal case may be filed in electronic form. Judge, this plainly says the indictment, information, complaint are the charging instruments.
There it is. Have a nice day.
I agree, Your Honor. That makes no, that
Well,
doesn't.
if he agrees, why are we arguing this?
Why are we arguing in the first place? Exactly.
Charging
No.
instrument in a Class C misdemeanor.
See?
Article 4
He's laughing because because he knows he's been caught. He knows he's been caught in his deception, but he's gonna try his best to weasel out of it.
Wait a second. May I respond to that?
No, Your Honor,
I'm still talking.
same issue.
You've been talking nonstop for like 20 minutes.
Article 45.018 and Chapter 45 is the specific section of the Code of Criminal Procedure for Justice and Municipal Courts. Chapter 45 of the Code of Criminal Procedure. 45.018 is the complaint. For purposes of this subchapter, a complaint is a sworn allegation charging the accused with the commission of an offense. 45.018 plainly says a complaint is the charging instrument. I have case law to that effect, Judge. Judge, I can go through every statute, every case law I have, if the court wants me to. I can do that.
I'm gonna give a ruling on the examining trial, I'm gonna deny
May I,
that.
may I address his
I've already given a
missteps?
ruling, I denied it.
Denied? denied an examining trial. Okay. Well,
Yep.
defense raises an exception to that.
Because you're not entitled to one. This is a misdemeanor case.
So where would you like to go then forward from here, Your Honor? Are you saying that you have found probable cause?
I said I am denying your examining trial. If you have anything else, you can go through that and you'll talk to Mr. Thomas about it.
Anything else about that?
About anything else that you had questions about?
No, I have no questions, Your Honor.
All right,
I just raise an exception to the denial of an examining trial.
okay, do what you gotta do.
All right. Your exception is noted.
I have to, again, I can't visit with Mr. He's not signed a waiver of counsel. I don't want him claiming that his constitutional rights are violated. So if he wants me to visit with him, he has to sign a waiver of counsel. Otherwise, I'd be happy to talk to him about this or any issue, but not, I can't until
Would
he
you like
signs
that,
that.
Mr. Thomas?
I don't see any reason to sign anything from him, but I guess I'm willing to take a look at it. We do have,
Well, in order to speak to either of us privately, we need a no contest, not guilty, something like that, just so we can help you get this taken care of.
no contest or not guilty.
No contest is not, you're not saying you're guilty, you're not saying you're innocent, you're
Well,
just in the middle.
My plea is there in the Code of Criminal Procedure, Chapter 27, which I believe everybody here knows that 27 is to be respected here. And it says 2701, the defendant's pleading, the primary pleadings are the indictment or information. Now, we don't have that, so what is there for me to respond to? 2702, subsection 1, says that the pleadings of the defendant shall be, and it lists off several different things that are pleadings. Now, I can plead, some of those say that I could plead to guilty or not guilty or no contest, but it also mentions, those are farther down, the first one, the very top thing.
And now he's now going all the way back to his initial plea. You see how when he loses arguments, he constantly tries to retread older arguments that have already been addressed? We already went through this in the previous hearing about the plea. We're way past that, but now he's going right back to it.
Thing there, subsection 1 says the defendants of the pleadings of the defendant shall be. You got a problem with your paperwork. I raise an exception to the indictment or information. There's some form problem, there's some substance problem. In this case, it doesn't even exist at all, so I could raise an exception to both of those. It has no form and no substance. Where is the indictment or information? I have nothing to respond to. I can't say no contest in all good conscience, as much as I would love for this to just be over and for, everybody to acknowledge that they made a mistake.
If you don't like my ruling, you can appeal it up to a higher court, but, I mean.
No, I'm not addressing the examining trial anymore.
Okay.
I've accepted your ruling, and we'll just go on. Yeah, accepted and accepted your ruling as well. And we'll just move on from there. But there's nothing for me to enter another plea to other than the plea I've already entered, which is 2702, subsection 1. There's a form or substance problem with the indictment or information, which actually I'm saying doesn't exist because Mr. Thomas failed to provide one. Mr. Thomas spent a lot of time talking about the complaint, and I can't respond to a complaint. I can only respond
Why not?
to an indictment or information.
Well, that sounds like a personal problem then.
If he had done his job properly, or let's say the DA's office had done their job properly, they would have followed Texas Code of Criminal Procedure 2.05, which says you take the complaint and you draw up an information in a misdemeanor. We're not talking about a felony, so there would be a different provision for that. But in this case, this is a misdemeanor, and they would take that complaint, they would draw up an information. They know how to do that. They've done it all. They do it all the time. Why did they not do it here? I don't know. But there's nothing for me to respond to. Perhaps the reason that they didn't respond to it in this case, obviously the burden of proof is on whoever's trying to accuse me. But it looks to me like if they had done that, they would have been perjuring themselves because there are no facts on the complaint. So even if the complaint somehow could, poof, become a charging instrument, which there's no basis for, even if it could.
It is, though. Again, he only selects which parts of the Code of Criminal Procedure he wants to recognize.
Facts for them to draw up an information on. They can't say, oh, based on these facts, it looks like that would be a crime. If he committed this, he did this, and it was posted that, all of these things that would be written up as facts. Oh yeah, I can see how that would be a crime. But they can't do that, Your Honor. They cannot follow Code of Criminal Procedure 2.05 and draw up an information based on the complaint because it has no facts. It's like one of those Easter eggs with nothing inside.
May I respond, Your Honor? Judge, it appears I'm going to be citing these cases whether we want to or not. Regarding the complaint as a charging instrument, Rios versus the state of Texas.
Now listen to an attorney who unfortunately had to go the extra mile with this jackass, but listen to an actual attorney this time.
718 Southwest 2nd, 730. That's the Court of Criminal Appeals. That's the highest criminal court in Texas. It says, while a complaint charges the commission of an offense, and that cites Article 15.04 of the Code of Criminal Procedure, it also has at least two discrete functions. One is to supply a basis for a magistrate to issue warrant for arrest. Another is to serve as a charging instrument for trial in municipal court. Article 45.01.
There it is.
Repealed.
Court.
Repealed.
Of the phrase, when an indictment, information, or complaint is filed in court, is a charging instrument upon which an accused may be tried in the court in which it is filed.
Your Honor, do we have to listen to him bring up case law that's based on repealed statutes?
He's so salty.
Repealed statutes from 23 years ago repealed?
And it wasn't repealed,
no. We have to listen to that? I think
it wasn't repealed. I believe the statute has been moved. It was repealed and reorganized in another section of the code, I think. So hold me to that, but I think that's what the case is.
We're past. Your Honor already gave a ruling about the examining trial, and I don't see any reason to keep revisiting that, especially with repealed faulty case law. What's the point?
What else do you have for today?
Well, I have quite a few issues ready for pretrial if we're going to go ahead into the pretrial part. Your Honor gave a ruling about the examining trial, and you're denying that. So I'm ready for pretrial. If we're going to pretend like they already have a case, then let's move on with that.
Unfortunately, this does continue. I know, but you guys signed up for this, or most of this. Here's part 2.
Your Honor gave a ruling about the examining trial, and you're denying that. So I'm ready for pretrial. If we're going to pretend like they already have a case, then let's move on with that.
You have anything, Mr.
I'll respond to whatever he brings to the court, Your Honor. Now, Your Honor.
All right, this is.
Mr. has been requesting discovery. I have discovery prepared to hand him. He'll need to sign for it, showing that he received it. He has sent a lot of discovery.
I mean, honestly, I could take a break, and we could, and if you guys want, we could stop here, end the stream, finish up, and then recharge and move on and have a part 2 on tomorrow. Tomorrow's Wednesday, right? Yeah, I'm going to be back on my normal schedule, so Wednesday and Friday. Or we can keep going with part 2. It's really up to you guys. If you wanna call it a day here, and then and try again. But I'll leave it to you guys. There's a lot more. There is This hearing, there's a lot more, and the trial itself is 6 parts. So the trial itself is going to be at probably possibly 2 live streams on its own. The actual trial. Hey, Deacon, thank you for the 10 gifted memberships. I wasn't planning on going into the trial this time around for sure. But there is this particular hearing is not done, and it's not close to being done. Unfortunately, Insane, there is no video of the trial. That's why this is like an audio only thing. I'm playing Skyrim in the front, so you guys have something to look at. But ultimately, this is an audio centric live stream today. How long ago? This hearing is October of last year, and the trial itself was November 29th. What do you want, Wiki? Yeah. Hmm? Yeah. Hmm? Hmm? Winston. All right. I think honestly we'll just go ahead and call it a day here. And we'll be back at it tomorrow for the rest of this hearing. So there you go. You guys get kitty. But I think this is okay. We're gonna stop here. And then hear the rest of the hearing tomorrow. I think it's a fine place to stop for now. I don't want to overload you guys. Because look, it's admitted that this guy is very extremely difficult to deal with. He really is. The ego, and the unearned smugness is pretty hard to take. So you only want to take it in pieces. But thank you, Taylor. Zaries, thank you for the $9.99 super chat. But thank you guys again. Don't worry. There is a happy ending at the end of this. I promise you. So at least have some solace there that there is a happy ending at the end of this ordeal. All right. But all right, guys. Shut up. Have a good night. Take care of yourselves. And yeah, I'll see you around. Adios. Shut up. Join my Discord and hit that like button on your way out.